the January 5th, 2022 Berlin Board of Appeals meeting. First matter on our agenda is the approval of minutes of our meeting of August 18th, 2021. Are there any additions or corrections? If not, is there a motion?
I so approve the minutes.
Second? Okay, all in favor?
Aye.
Okay, they're passed. The next is the request, a variance to the side yard setback for construction of the new single-family home. Applicant Michael O'Neill. And Mr. Engelhardt, will you give us a review of the application, please?
Yes, sir. This is for a property that had a previous home on it, so the address would remain at 605 William Street. Previously, the house that was on the lot was taken down under a demolition permit in 2004, according to our records. And the applicant would like to, has since purchased the lot fairly recently, within the last 2 years, I'd say, within the last year and a half, and would like to erect a new home on the site. And to my knowledge, it's a manufactured home. And the size of the home at 60 foot would require an encroachment into the, I would call it the south side setback of 6 feet, where by code in the R2 residential district, it should be 12 feet. The other side is the minimum, just over 8 feet. You need a sum of 20 for the setbacks. So the proposed house, according to the survey that was given to you in your packets, is only 6 foot .09 off the property line, and he needs to be on that left side of the house 12 feet. So he needs a variance from the side yard setback to encroach.
And excuse me, David.
Mr. Chairman.
Yes, sir.
I'm going to address something now before you go any farther because it may affect what you're about to ask. We've revised the site plan.
Right.
And so the landings and the steps shown on the rendering you have on the left-hand side have been eliminated.
Oh.
So the amount of the encroachment is much less. In fact, both sides of the house. Now, let me give you these documents, Mr. Chairman. So first,
And is that a revision of this,
Yes.
what we have
Yes.
from Greg Wilkins?
Well,
Yeah.
it is. So let me give this first, and that's, I'm going to ask marked as applicant's exhibit number 1. You'll take one, Mr. Bunning, and hand them down. And I've given copies to Mr. Engelhardt of all these documents, okay?
Okay, so this is the correct
That's the correct
proposed provision.
That's correct. And
All
you'll
right.
see that the landing, which measured previously 4 by 4, and the steps have been eliminated.
Right.
So that now, and under the R2 section of the Berlin Code, it reads you have to have a minimum of an 8-foot side yard setback, but then it has that additional caveat that quite honestly I was unaware of and I'm not used to that says you need a combined 20 feet.
Right.
So now you have the minimum 8 feet on each side, you just don't have the combined 20.
Right.
So the next exhibit,
Well, hold on.
Go ahead.
Before you get, I know it's tough to stop you when you
Yes,
get
it
on
is.
the roll.
Yes, it is.
But, I think you probably, for the record, should identify yourself and who, if anyone, you represent.
Well, for the record, Mark Spencer Cropper, 6200 Coastal Highway, Suite 200, Ocean City, Maryland. I know you've seen me appear before this board with some rather questionable clients in the past, and apparently it's going downhill. So my client this evening is Mr. Will Esham, who is the owner of the subject property. The property is owned by 2 LLCs.
Right.
One of which, Mr. Esham, is the sole member and managing member, and the other LLC is managing member is Mr. Mike O'Neill. So I'm representing those 2 LLCs
Right.
as the applicants for the variance this evening.
So Mr. Esham is your client this evening,
Yes, sir.
and you have hit bottom.
It doesn't go any lower.
No, it doesn't. Now, let me say for the record, probably most everybody knows, both of these characters are my cousins. And frankly, when I saw Mark I thought, well, we got to put up with him, but then when I saw Will, I didn't realize that he was the owner of the property. If you all feel that I should step aside, I will do so. However, Mr. Cropper will be the first one to tell you that his relationship with me has never stopped me before in my criticism of him on a fairly frequent basis. So if you want me to step aside, I will do so.
No, I do not want you to step aside.
Okay, all right, with that,
So with that, you have the exhibit number 1, applicant's exhibit number 2. Applicant's exhibit number 2 is a rendering, black and white rendering of the exterior of the house that's proposed for this lot. So I'll have Mr. Bunning hand that down.
Yeah, first I heard about it, though.
and you're providing copies.
I've already given copies to Mr. Engelhardt.
Right.
Then,
These are numbers, if you want the numbers, 1 and 2, or are they all numbers?
That's okay, Woody, you keep it.
number
And
3.
we'll give those to Carolyn.
Applicant's number 3 is a colored rendering, it's an actual photograph of the house that will be built on this property, should the board look favorably on the request. Applicant's number 4,
Excuse me.
Yes, sir.
Mr. Cropper, the photograph does not exactly comport with, the photograph has a front porch, which does not appear to be on the,
but the dimensions are the same, is that correct, Mr. Eshelman?
Yeah, there is.
okay, and the porch
There's a porch.
is shown,
On the rear?
yeah, is shown on the plan, but it's not on your elevation.
Okay,
Yeah, I just wanted that
okay.
to be there.
So then, applicant's number 4 is an email exchange between Mr. Eschel and Mr. Girardi that owns the property to the south or left-hand side, wherein he has indicated with the removal of the landing and the steps, he does not oppose the variance. And then applicant's number 5 is an email exchange between Mr. Eschel and Megan Foley, who owns the property to the right, again, indicating that she has no opposition to the variance, should the board choose to grant variance. So, Mr. Eschel, I have represented to the board that you and Mr. O'Neill, through 2 LLCs, are the owners of record of this property, is that correct?
All right, now hold on.
Okay.
For the record again, Will is an attorney, so I do not, and maybe I'm prejudiced, I don't consider it necessary to swear in an attorney because under their obligation as a member of the bar, they have to tell the truth. So if that's all right, I'm sure he'll
Does that always
testify
work?
truthfully.
Joe,
Yeah.
does that always work?
I know more lawyers that it doesn't work than lawyers that it does, but they're not present this evening, so, yeah.
So, Mr. Eschel, as indicated, through the 2 LLCs that are record title owners of the property, you previously submitted a site plan to Mr. Engelhardt, which is identical to what has been submitted to the board, except for the fact that the landing and steps had been removed from the left-hand side of the structure. Is that correct?
That's correct.
And it is your desire to have the house located perpendicular to William Street, but you can see from the lot lines of this particular parcel, the parcel is not perfectly square to William Street. So the lot lines are a bit angled. So for the house to be perpendicular to William Street, it's not going to be perfectly aligned to the angle of the property lines. Is that correct?
That's correct.
And you can't achieve both on this particular property. There's no way to achieve both. Is that correct?
That's right.
And if the house were turned so it was more directly aligned with the property lines on the left and the right, it would lessen the amount of needed encroachment, but because of the combined 20-foot provision of the code, you would still require a variance. It would just simply be lesser of a variance because the sides of the house would then align more closely with the alignment of the property lines, correct?
That's correct.
All right. And what has been marked and presented to the board as applicants number 2 is a black and white rendering by Eagle River Homes, and that is an accurate depiction of what you would propose to build on this property, again, should the board look favorably on the requested variance.
That's
Is that
right.
correct?
That's right.
And all of this information was shared with the property owners on the right-hand side and left-hand side, one on the left being Mr. Girardi, and on the right, Ms. Foley. And as indicated in Exhibits 4 and 5, they support the requested variance. They don't oppose the requested variance. Is that correct?
That's correct.
And it's also true, I believe, that until you had discussions with Mr. Engelhardt and then conveyed them to me, you were unaware of the unique provision of the Berlin Code, which is in sort of the R2 section. Actually, it is section 108-350, where it indicates the side yard setbacks. And with the side yard setbacks, they have to be a minimum of 8 feet, but the sum of widths is a combined 20 feet. And as proposed, you meet the 8 feet, but you are just shy of the 20 feet. Is that correct?
That's right.
And when you came and met with me about this, and I'll be the first to admit this, this is for me, this is a very unique provision of the code. Of everywhere I do land development, I've never run into this where you meet the minimum setback, but you have a combined setback that you also have to meet. I know we don't have that in the county in Worcester and Wycomico, but apparently we have it here in Berlin, and I now understand there are some areas in Ocean City that may have it, but that's a very unique provision that I'm unfamiliar with. But it is what it is. So the request before the board is to get the variance so that you can position this house on this property. And that'll be our case, Mr.
Okay.
Moore.
Is there anyone in the audience who wishes to speak for or against the application? And Carolyn, help me, are we on the website so that people can make comments?
We're on Facebook.
But it is not a hearing where we need to
No.
wait to receive comments digitally?
No.
Okay, all right. So let the record reflect there's no one in the audience for or against. Any questions of board members?
I have a question. Go ahead, Woody, I'm sorry, he said on board members.
Actually,
No,
well, go ahead.
no, go ahead, Dave.
I'm just looking at, and again, I didn't have these for packets previous to give you, but I'm looking at the photograph and I'm looking at the elevation. They differ.
Yeah.
And I just wanted to clarify that, that's all. The photograph looks like a smaller model than this 60-foot one that's shown in the black and white drawing. And if you notice, it's got 2 windows on the driveway side. This has 1, and then 2 more windows, that's fine. But in the photograph, there's another window missing. It's probably because it's a wider version, the one you're proposing.
Right.
So you have that, you see that bathroom vent in the middle on the left side of your drawing. That's what that is. That's for a bathroom vent, for a bathroom light where the shower is probably. You have 1 more window in the version that I think Mr. Esham's going to want to put there, right?
I can clarify
Go ahead.
your comment. As you know, Mr. Engelhardt, my partner Mike O'Neill's been talking to you on this, and he's
Right.
out of town, so I'm sitting in. And I had asked him to provide a picture of the home, because he only had the sketch. So I believe the picture he provided is taken from the Arcadia development down in Newark.
Okay.
That may not, I think he did it in a hurried fashion, because I think it was done yesterday, maybe because the snow's out there, but the actual home is the sketch, and it is the dimensions that's shown on the plat. So I'm not sure that the color picture is completely accurate.
Yeah.
Okay,
If that
well, we'll take it
clarifies.
for what it's worth.
Yep, yep. I just wanted to point that out.
Yep.
Difference.
Thank you. Yes, Mr. Bunning.
My comments really aren't, I mean, the project looks fine, the house looks fine. It's more about what our requirements are as a board. We have some limitations that we have to address here. One section of our code is called 102, section 104. The limitations of granting variances. That there has to be a showing of good and sufficient cause dealing solely with the physical characteristics of the property. Now, the zone, an R2 zone allows a 70-foot wide lot. You have a 79-foot wide lot. And you're in here asking for a variance when you have a lot that's 9 feet wider than the majority of the properties that are allowed in R2 zone. I don't see in this particular case where there's a hardship. I know you referred to the angle of the lot and how it doesn't parallel the street, but this lot wouldn't fit if it were parallel to the street, because it goes from a 79 something dimension to a 78. The house shouldn't be designed for the lot at all, in my opinion. That's the only point I want to make. I feel like for a variance like this to be granted, then anybody applies for a variance just because the house doesn't fit on the width of the lot they have. It just seems too general. You see what I mean? There isn't a specific hardship here that separates this lot from other lots in an R2 zone. And that's my point. I mean, the project, the house, I have no problem with it, but it just doesn't fit the lot. If you want to address my concerns, that's my only opinion.
Well, I'm going to address it two ways, if I may. One is under section 108-163 of the code. It says, "The Board of Appeals shall have the power to hear and decide application for conditional uses or for decisions upon other special exceptions or exceptions on which the board is authorized by this chapter to pass. The board shall have the power to authorize on appeal in specific cases a variance from the terms of an ordinance, and such application shall be deemed to be for special exceptions authorized by Maryland Annotated Code, Article 66B, Section 47. So while I'm certainly familiar with the provision of the code you're talking about, I remain just a little confused by that section of your code, 108-163, and whether the appropriate criteria for this is the variance criteria under 108-165, or whether it's the special exception criteria under section 108-166. But regardless, for any variance, you're correct, you need to show that there is some unique condition or circumstance regarding the property or the structure. And in this case, as there's already been testimony, this lot is not aligned perpendicular to the road, and in the effort to align the house perpendicular to Williams Street, it's inconsistent with, again, aligning the house with the right and left-hand property lines, which I believe is a unique condition or circumstance. I also believe that the provision of the code that's applicable here, where you have a minimum 8-foot side yard setback, which this does meet, but you then have the supplemental combined 20 feet, I believe that is in itself a unique provision of this code that I do believe is unusual and has a disparate impact on locating this house on this lot. because it does meet the minimum 8-foot setback on both sides. As far as the hardship, I guess the hardship to Mr. Esham and Mr. O'Neill is that they're trying to position a house on this property that is consistent with the neighborhood. They don't want to put a house on this property that is too small and would be not in keeping with the character of the neighborhood. So that's why this particular house was chosen. And therefore, from their perspective, there would be a hardship in a way that they were trying to put as nice a house as they can on this property for not only their benefit, but the neighbors as well. Clearly, in this situation, you could put a smaller house on this property and not necessitate any variance. There's no doubt about that. But this house is what they believe would be most appropriate for this lot and for the neighbors and keep the property values up.
Well, regarding that, I know that the two houses that adjoin this property all exceed the 8-foot, 20-foot total setbacks. They do not, in other words, they don't meet just the minimum.
Right.
I think one of them is up close to 25 plus feet, and another one may be in the same range. So, I mean, it's not like the neighbors that we have letters from are closer to the property line than what the code allows, even though our code, like you say, is somewhat unique. Apparently, it's not unique to me because I dealt with Berlin for so long.
Right.
But there are other R2 subdivisions in town that have dealt with this on all their lots. And that's my
Understand.
concern, that's all.
Let me, I will tell you that when I looked at the plan, I thought that I did realize the additional setback. But when I looked, I thought that the situation brought up by Mark was what probably they would be talking about. That's kind of the skewed configuration of the lot, which creates areas that otherwise would be able to use. But then I looked at the code and I found, and we went through this in probably excruciating detail, actually in the Pino Tomasello case, where Hugh Cropper came in and had a variance request as well.
Now, please tell me you're not going to compare me to Mr. Hugh Cropper.
No.
Thank you. Let the record reflect.
Yeah, no relation between the two of us. But when I look back, because I recalled what we went through that evening, which was, of course, a pretty substantial circumstance with a lot of objection from the neighbors. And when I reviewed the variance provisions in 108, 165, just as Ocean City's code, Berlin's code is a little unusual because it says that where a variance is requested, the burden is upon the applicant to show that the requirements of the article would involve practical difficulty or would cause unnecessary hardship. And for the record, I do a lot of zoning work in Ocean City where I represent applicants, and I generally and repeatedly, until they're tired of hearing it, refer to Anderson versus Board of Appeals, which is 22 Maryland Ave 28, and we read that the night in the Tomasello case. And what Anderson versus Board of Appeals says is that where an ordinance has the two alternative standards, it has the practical difficulty standard as a less burdensome provision related solely to setbacks. And it says where the standard of practical difficulty applies, the applicant is relieved of the burden of showing and taking in the constitutional case, which is required under the undue hardship standard. In order to justify the grant of an area variance, the application needs show only that whether compliance with the strict letter of the restrictions governing setbacks, bulk, density, etc., would unreasonably prevent the owner from using the property for a permitted purpose, or would render conformity with such restrictions unnecessarily burdensome. So it's a more benign standard as to if you all determine or we determine that complying with the strict provisions would render conformity unnecessarily burdensome, then you can determine that in your own judgment. And then it says whether to grant the variance applied for would do substantial justice to the applicant as well as to the other property owners in the district. So that's really where we are. If you deny it, then does it cause it unnecessarily burdensome without creating an injustice to the other owners in the district? So that's your standard of determination. And with that, I'll leave the discussion to you all.
Well, how would denying it create an injustice for the,
Well, I say that's for the judgment of the board. Whether the variance applied for does substantial justice to the applicant as well as to the other property owners in the district, meaning have you done the right thing for the applicant as well as the other property owners in the district? That's the substantial justice that they're talking about.
And that's where the neighbors come in mostly, on that perspective.
well, that's why I pointed out the neighbors meet the setback requirements, even the.
Right, but even so,
total-
the neighbors here have indicated they support this variance, so there's no injustice that's going to occur to the neighbors should you grant the variance.
Yeah, I understand that point. There's one other point that I could make too regarding what our responsibilities are on the Board of Zoning Appeals, that if this, like you say, our zoning code, the 8 plus and the 20 total, being unique, should that rule be changed so it applies to everybody, 8 and 8? And if we're going to have a setback of 8 and allow 8, then shouldn't it be more of a general approval? Or, you know, a lot of people have complied with the 8 and 20 over the years. And they may have wanted to build bigger houses too. That's my point.
Gentlemen?
Yeah, how do you all feel about it? Again, I really don't have a problem with the house. The house is going to be nice, it's going to be beautiful, it's a beautiful lot. I'm talking more about kind of a precedent that we set by just asking for a variance on a 79-foot lot. Technically, the lot could be 70.
Well, let me say as far as a precedent, and variances are unique in that regard, and variances by their very nature are site-specific. So I don't think a ruling in this matter with regard to this lot creates a precedent that would be binding on others on other properties. And I think the law is pretty clear on that. The variances are all, each and of themselves, site-specific. I understand what you're saying.
Yeah, I know what you're
And I think our position would differ if we didn't meet the minimum 8-foot setbacks.
I agree with that.
And the fact that we do meet the minimum 8-foot setbacks, and it's only the combination creating the 20 feet, and the fact that we believe it's advantageous to not only this lot and the owners, but you have neighbors that support it as well. I believe that the practical difficulty standard that Mr. Moore was talking about is quite candidly met. But again, that's a discretionary decision that you all have to make, whether you think it is appropriate under the circumstances to grant this variance or not. But we wouldn't be here if we didn't meet the minimum 8-foot setbacks.
Dave, let me ask you, what is the purpose of the 8 and a total of 20? Why would it be in our zoning?
Open space, open space, separation of, between dwellings. If you think about it, if you were in a subdivision where you had, your house is a minimum 8 off the line, and I'm next door, and I got a minimum, you got at least 16 between the houses, just for open space, for green space. And I assume instead of putting in, I don't know, wasn't here when they wrote that section of the code, but I assume they had looked at a lot of places where it's 10-foot side setbacks, on smaller lots, so it should be 10 and 10, but they wanted to give some flexibility where some of the lots were oddly shaped, or on a cul-de-sac where they're pie-shaped. They had to make some kind of accommodation for how houses are placed, so.
That makes sense too, so possibly if they were preparing this code to be conformed on both sides, they would have gone 10 and 10 and not 8 and 8.
Right. Right.
That's a good point.
And then the other thing, the house that was previously there, I don't recall, but many of you have been here for many years, maybe you recall.
I did a subdivision of this property in 1986 and I didn't show a house on it.
Okay.
So I don't know when it got done.
Well, it said 2004 in our files, but I didn't have a site plan in there showing the former house, so.
So we don't know what size it
But
was.
the old SSTAT sheet from, State Department of Assessment and Taxation is in the file. And it showed a house of, I think it was 1,462 square feet. So it was not a large home to begin with.
Right.
It was probably a 3-bedroom, 2-bath home, like one of the neighboring homes.
Yeah, that's where Bill Lucille Brown built, right?
Yes,
Well, no, that house is still there, but
Oh,
I have a
okay.
feeling.
But
it was a
she owned the lot.
2-story house.
but she
Oh,
did own,
okay.
It was where
I-
Mrs. Reed lived that she taught. me.
Mr. Hudson owned it, and then Lucille Brown owned it before that house was torn down.
Right.
Lucille Brown was the one who subdivided the property, because that's who I did it for in 86.
Okay. So I guess
So
she,
it was a house on the property, but it was a 2-story house.
okay.
And I'm not sure it sat on this particular lot as it sat on the whole property, because part of the subdivision included church property.
Okay.
Right, they owned a lot of property, it went back very deep behind, right, and behind the church? Yeah. And I guess she inherited it back in 85 or 86. And she passed away, I think, last year. So the lot got sold first, and then the home she was living
I guess my only other question would be, why this house? Why not a house that fits?
Obviously, there could be a smaller home that could, if we're going this manufactured home option, they have a smaller home that we could buy that would not take up as much coverage on the lot. I mean, the lot's huge, we're not covering a lot of the lot. We have it in line with the other homes, so it's not sitting back.
Yeah, the lot is huge, it's like 200 feet
So
deep.
for open space, we have a lot of open space, it just happens to be in the rear of the lot.
Yeah.
So we could certainly cover more of the lot and take up more of the lot if we wanted to, but we're not choosing to do that for leaving the open space. It just happens to be whole. The location of the home is more driven to be in uniformity with the other homes.
but it's not very deep, a home isn't very deep.
No, it's kind of like the
So-
home that Mrs. Brown lived in. It's kind of similar to that home.
Right, so it could be, instead of being 60 wide, it could be a 54-foot model and be 30 deep, correct?
I believe that company would probably have an option like that, but my partner knows more about that.
Yeah, I have no more questions.
Mark,
Yes, sir.
the section that you read, are you saying that there's a provision of the Berlin Code that says a variance should be treated as the same as a special exception?
I ran across this before, Mr. Moore. It's section 108-163, and I was taken aback a bit when I found it. And I'll read it verbatim again. It's 108-163. Conditional uses, variances, and special exceptions. The Board of Appeals shall have the power to hear and decide application for conditional uses or for decisions upon other special questions or exceptions on which the board is authorized by this chapter to pass. The board shall have the power to authorize on appeal in specific cases a variance from the terms of an ordinance. All such applications shall be deemed to be for special exceptions authorized by Maryland Annotated Code, Article 66B, 6407. So I don't know why that provision's in there, but it is. And so when I read it, I had to question whether the appropriate standards for this matter are the special exception standards or the variance standards. But I just wanted to bring it to your attention because it is in your code, and I don't know why it's in your code.
I've got the section in front of me. The difference for the board members is that special exceptions are presumed to be granted unless there is something uniquely detrimental about the area upon which they're requested. So the whole burden of proof is flipped from proving unnecessary hardship or practical difficulty, which is a standard on them, to a special exception. It's presumed that the mayor and council wanted it to be granted as long as it wasn't uniquely detrimental. So it flips the whole thing around, and not to doubt it, because I'm reading it, it says what it says. And I don't know, I don't know how it got in there, but it's in there.
And so as Mr. Moore indicated, and because I've argued this 1,000 times at the county, as a special exception, it's deemed what they call presumptively permitted. And unless someone can establish that this particular use on this particular property is somehow more onerous or more detrimental than it would be on another property of similar zoning, it should be granted, which, as Mr. Moore indicated, is a much different standard than the variance standard. You don't have to prove unwarranted hardship. But anyway, look, this case, it is what it is. Obviously, Mr. Eschel and Mr. O'Neill would very much like to put a nicer house on this lot, a longer house. But to do so, it requires this variance that's being sought. And again, not to beat the horse dead, but I do think it's important to note that it meets the 8-foot minimum side yard setback. It just doesn't meet the 20. And with the neighbors supporting the variance, obviously they deem it to be in their best interest to have a nicer house on the lot than would otherwise be allowed. So for those reasons and all others, we would just ask you to hopefully find that we've met the burden and grant the variance.
And I would suggest that you should concentrate on whether denying the variance would unreasonably prevent the owner from using the property for a permitted purpose, or would render conformity with those restrictions unnecessarily burdensome.
And there's another section of the code, 108-165, under variances, which is specifically for variances.
Oh, yeah, no, there's
Yeah.
no question, and that's what I was reading from with the practical difficulty and undue hardship standard. There's no doubt that that's in the code.
Yeah, I'm not questioning what your code says regarding 165.
Yeah.
But yes, how do you fit in B1 to what you're referring to, that there are exceptional or extraordinary circumstances or conditions applying to this property in question or to the intended use that do not apply generally to other properties or classes of uses in the same district? I mean, how does that statement apply to this case? That makes it different or exceptional? And it all comes down to that. You know, should it be 8 total 20 or 10 and 10? And again, the house looks nice. Yeah, it would fit. I'm not saying that. It's just.
Yeah, you're concerned about the standard of the code, I understand that.
Well, that and the fact I've done a lot of R2 subdivisions in this town where we had to abide by the 8 and 20, and it's never an issue. But I understand it's also unique, so.
Any questions or discussions? If not, it's time to have a motion.
I would move that we approve the request.
Is there a second?
I second.
All right, all in favor of approving the request, say aye.
I
And opposed?
No. I oppose.
Yeah, okay, 3-1. So,
Thank you very much.
So we need 4.
no, we need a majority of the quorum. Yeah, under that, yeah, that's a good point. Normally, we have 5 board members, but under the provisions of the law is that you need a majority of the quorum. As long as you've got a quorum, you can legally act. So, yeah.
Thank you all very much.
Thank you.
And Happy New Year.
Well, and I want to say that, and just simply as a comment, Woody's comments are well taken, and as are Mark's with regard to the circumstances of the code. Frankly, there are some conflicting standards.
I'm not upset by it, I just,
No, I know.
Hey, Morris.
Yeah.
Excuse me. You didn't
Yeah,
give-
well, and I will say, for the record, that even though zoning is not a plebiscite, the fact that the neighbors are in favor of it does make a significant difference. Okay, Carolyn, I think we stand adjourned unless there's anything else. Yeah.
All they
Thank you all.
have to
Thank you.
do is turn the house 90 degrees and it's fair.
You don't want that, you don't want that.
We got into it a little bit, and I thought,
yeah, I'm kind of anxious to hear now what Frank's response is to,
Well, Frank,
let's
you
say,